Cuddy Law Firm in Valhalla, New York, and I practice primarily in the special needs planning, guardianship matters. I know we have a few people coming on, so I'm gonna wait a few more minutes before I commence. Does anyone need Spanish translation? Buenas tardes, mi nombre es Katherine Aquino-Melendez, soy abogada en la oficina Cuddy Law Firm. Practico principalmente en la planificación de necesidades especiales y las tutelas. ¿Alguien necesita traducción en español? Okay, perfect. Thank you, Russ. So today the presentation will be on guardianship, and I'll touch on some other aspects of planning for adults that you can consider. One of the very first things you should consider when planning is advance directives. Advance directives are documents that you want to have executed at an attorney's office, because some people will print them out from LegalZoom or whatnot, but they're not always inclusive of everything that the law requires. And there's actually recent legislation seeking to make these documents simpler, such as the power of attorney and the gift writer. With that said, you have to be 18 years of age to sign or execute these documents. Now, what are advance directives? Advance directives include a power of attorney and a gift writer, a healthcare proxy, a Hepa Release, disposition of remains, and a living will. If you have capacity to execute these documents and understand what you're signing, I highly recommend that you do so. And these documents are especially critical during this pandemic period that we're living in, including the power of attorney and the healthcare proxy, right? Because the power of attorney allows you to appoint an agent to make legal decisions for you or business decisions for you if you aren't able to do so yourself. A healthcare proxy allows for you to appoint or assign a healthcare agent to make health decisions for you. So in case you're hospitalized, someone can make decisions for you if you aren't able to make them yourself. Same goes with the power of attorney, right? If you're in the hospital and you need specific transactions to take place, your agent can act on your behalf with your authority, because they are a fiduciary to you and they should act in your best interest. A Hepa release is exactly what you know it to be, a document that allows you to disclose medical information and records of the individual. Usually you're allowing for your healthcare agent, your power of attorney, potentially maybe your attorneys and or guardians to access your medical information. It's not specific to a specific doctor's practice. Like when you go to the doctor's office, you sign a Hepa release. This is a general form. Disposition of Remains is a form that allows for you to communicate your wishes of how you want your remains to be disposed when and if the time comes that you are no longer living. If you want to be cremated, if you want to donate organs and or tissue, that document allows you to make those decisions, and your agent should comply with what your wishes are. And a living will allows for your agent to communicate to a medical professional your wishes on life support, artificial nutrition, respirators, etc. So again, Anyone and everyone who has capacity to understand and execute these documents should have these documents in place. This is also applicable to your children, right? If your children are 18 years of age, they too can execute advance directives. Typically, I don't have them execute the disposition of remains or the living will because those two are very delicate and more advanced documents for a youngster, a teen to understand or at least wrap their head around. A little morbid to even think about what you want your life, how you want your remains to be disposed of. But some clients want their children to have these documents executed as well, and that's fine. But again, typically I don't have them do that. Adrian, I don't have a PowerPoint available. I just started the presentation, only touched on the advanced directives. So you didn't miss out too much. Now, if your
Thank you.
Of course, if your son or daughter doesn't have full capacity to execute the advanced directives, there's supported decision-making to consider. And supported decision-making allows for an individual to make choices with their, for their own lives with the support of a team of people. It's an alternative to guardianship, which I'll touch on in a little bit. Just one caveat, it's not legally binding in the state of New York. There's no legal authorities in the state of New York. However, there have been several guardianship petitions denied or even reversed because supported decision-making exists in the state of New York. So that's something to keep in mind, that supported decision-making does exist. It's not ideal for everyone, and there's a lot of talk about whether guardianship should be eliminated as a whole, and because supported decision-making exists. But if you have an individual who's severely disabled, maybe even nonverbal, just again, severely disabled, it's probable that they won't be able to make any decisions, even with a team, on their own. And so guardianship would just be the most appropriate avenue. If you'd like more information on supported decision-making, you can always go to the supporteddecisionmaking.org website and look at information for each state. There's orders for the state of New York, which, as I mentioned, have been overturned and or denied. Now, there's two types of guardianships. One is an Article 81 guardianship. Article 81 guardianship happens in Supreme Court, and it is a lot more involved because there's mental hygiene authorities involved, there's guardian ad litems appointed by the court, financial affairs have to be dealt with if there's any financial affairs, there's a lot of evidence that has to be disclosed, and it's a lot more involved and pricier. This usually will allow for an individual to be appointed either a guardian of the person and or property. Now, all Article 81 guardians in New York have the same powers. Sometimes a judge may choose to appoint an individual to be the guardian of the person's property only. Maybe they'll appoint someone else as the guardian of the individual themselves. So something to keep in mind. Usually with Article 81 guardianships, you hear of these with older individuals, right? Individuals maybe with dementia, the Alzheimer's. Those are usually the cases where an Article 81 will happen. Sometimes though, Article 81 guardianships are mandated by judges for individuals, but everything is a case by case. And now an Article 17A guardianship. This is special to New York State. It is not something that exists in other states in the country, but New York State. What an Article 17A guardianship is, it's a petition to the court asking for legal authority to remain the guardian of an adult, usually an adult child, once he or she has reached the age of 18. So if you want to continue your parental rights, let's say for your adult child, then you want to consider an Article 17A guardianship if your child has a disability. They have to qualify for this type of guardianship with either a developmental or an intellectual disability. There's a lot involved in this, but this is something that you do not need an attorney for. It is helpful if you have an attorney because there's a lot of little pieces involved, such as service, and if it's potentially going to be a contested guardianship, meaning there will be conflict, say parents are divorced and mom wants to appoint person A as a co-guardian or a successor guardian, but dad doesn't agree, then I would recommend that you seek the assistance of an attorney. However, as I said previously, you do not typically need an attorney for these types of guardianships. In fact, the clerks at the clerks at the court are very helpful. Sometimes they like you more than they like me. So, they're more than happy to help and provide guidance. The forms can be found on the website, and Amanda will include a link for the courts. They're usually even fillable nowadays, so you can even fill them out online and print them out. You can go to the court when and if you're able to get to the court these days, and they usually, or at least prior to COVID, the court clerks had the packets of information and documents that you needed. Who needs a guardianship? Usually when you think of a guardianship, again, it's someone who has an intellectual or developmental disability. There are individuals that petition for guardianships of their children when their child doesn't really qualify for a guardianship. And in part, that's probably why there's so much, trends to eliminate guardianships and only have supported decision-making in place. But usually, if you do it right, an individual with intellectual developmental disability is the person that will qualify for a guardianship. And they're incapable of managing their own affairs, right? Either, again, their person and or property. And so for guardianship, you will go to the surrogate court in the county where you or your child resides, and your questions can be answered by the clerk if you're representing yourself pro se. If you have an attorney, your attorney will handle everything from completing the forms to filing, serving, and appearing on your behalf if appearances of the petitioners is not required. Sometimes only, for example, in Westchester County, the surrogate usually only requires for the attorney to appear if the petitioners have an attorney and the petitioners do not have to appear. In New York County, I know that the surrogate requires for the petitioners and the attorney to appear together. Hearings vary. The judges, the surrogates have their own rules in every court. So again, you have to abide by what they require, not by what your friend's experience was. Filing for guardianship, like I said, it's a lot of, it's intricate. It's doable, but it's intricate. You need to complete a petition as a petitioner, and this is usually whoever is going to be the proposed guardian. You will also have doctors complete affidavits or affirmations regarding their credentials and their evaluation or visit with the individual, the ward, as the court recognizes them, or respondent, the child or the individual that you're seeking guardianship over. The physician's affidavits should be completed by either 2 physicians, one specializing in developmental and intellectual disabilities, or a physician and a psychologist. You'll need consents, affidavits, waivers, and OCFS forms. And we'll go through these a little bit more in detail. So the first one, right, the petition, like I mentioned, it asks several questions about your background, your address. There's even your education is inquired about, any criminal activity. You cannot have committed any felonies, and sometimes even misdemeanors, to be appointed a guardian. So, but you also want to be very honest with the court. There have been instances that petitioners have had misdemeanors that were, when they were young adolescents, and the courts have still appointed them guardians. But it's better to be honest with the court than for that to come about as your petition is in the judge's hands. Then you have to indicate who your standby guardians are. So who is going to be a backup to you, who the doctors are, why you should be appointed guardian, how you know the respondent, right? Sometimes it's not just the parents petitioning. Sometimes it's maybe the uncle and aunt, and you've known this child because they're related to you. Maybe it's the neighbor, and you've known this child for since they were born. So you want to explain to the court the relationship that exists between you and the respondent. Can we please maintain our mics on mute, please? Thank you. The doctor's affidavits. Make sure that the doctor, whether it's a physician or psychologist, has seen your child or the young adult or even adult, because sometimes you see guardianship when the individual is probably in their 30s. They've seen this individual within the last 6 months or a time frame indicated by the surrogate court. Make sure that the doctor answers every single question on that form. Usually what holds up the guardianship process are these forms. The doctors forget to check something off, don't complete it to its entirety. Sometimes they reference evaluations but don't include these evaluations. Make sure that if there's an evaluation being referenced, that it is included with their affidavit, so that the courts don't have to contact you and say, we need this evaluation. You're submitting everything to the court complete. Also, make note that at least one of the doctors, potentially the psychologist, references a recent psychological testing. Sometimes you may even seek the psychologist at the school, right? Your child is ready to transition out of school. Get a recent psychological evaluation done. If you have outside evaluators, even better, right? Always get a recent psychological testing to go along with your doctor's affirmation. Then you'll have affidavits of the guardian. How long you've known the respondent, right? Your background, your educational background, the convictions, forfeiture of bail, criminal charges, addiction to narcotics or alcohol. And these are questions that are a little invasive, but the reason is because the court needs to assure that you are an appropriate guardian for this individual. Usually an individual with disabilities that will not be able to manage their own life. So they want to make sure that they're granting this right to someone who is going to be able to care for the individual. Another form that's a little tedious is the OCFS form. And this is a form that requires you to provide 28-year address history. So you really have to jog that memory to compile all of your addresses for the last 28 years. This allows for background checks on adults regarding child abuse, as well as the children to see if they were ever abused. Some courts also require standbys to complete this information. Sometimes it's only the proposed guardians. Again, it varies court to court, and just make sure you know what the court that you're petitioning to requires. Waivers. Waivers allows for individuals to resign to waive their application as guardians. Sometimes it's even an adult sibling that's not being a proposed guardian or standby guardian. So the adult sibling will waive their right to being appointed and also served. Sometimes it applies to standby guardians. The consent is for standby and alternatives to service, right? They consent that they don't need to be served with the citations of the court. Once you have all of your documents in place and completed, you will file that petition to the local, your local surrogate court with all the supporting documents. Court will then issue a citation, and this citation includes the hearing date and time, as well as the hearing room. You serve the citation on your child, if that, or the young adult, right? Any interested party, including the home or residential placement where your child or young adult resides. You'll also need to send copies to mental hygiene legal services of the petition and the citation, the group home, as I mentioned, and file affidavits of service with the court, indicating that you have served everyone that is required to be served and put on notice, of the guardianship proceeding. Sometimes courts will require additional aspects to the guardianship petition, right? New York County usually requires fingerprinting of the guardians, and even now standby guardians. Next month, they may not require they may not require standby guardians to be fingerprinted, but currently they are requiring that. Westchester County doesn't require fingerprinting. What usually does take place uniformly is an interview with mental hygiene legal services or a guardian ad litem that's appointed. And this is an individual who's going to represent the respondent, the ward, right? The individual who you're seeking to take their rights away from. And the attorney for mental hygiene, or the guardian ad litem, also known as a GAL, will interview the individual and will interview the proposed guardians. Sometimes they may even choose to call the standby guardians. It's up to their discretion who they contact, but they want to make sure, one, that the individual actually needs a guardian, that the guardian or the proposed standbys are appropriate individuals to care for this individual, right? So they'll interview whoever they want to interview, and if they want to contact them once or twice or even visit the home, they can do that. And compliance is recommended that, because they will prepare a report and submit it to the court. And if you don't allow them to come to your home for whatever reason, that may be something that they include in their report to the court and can be either questioned by the judge and or maybe a reason for the denial of guardianship. Parents sometimes, worry when mental hygiene contacts them and says, we want to go and interview the respondent, because maybe it's an individual that has some capacity and, they're afraid that they'll say, well, I don't want my mom and dad or, my mom to be the one making decisions for me. Like, I like to go to the doctor's office and I speak to my doctor in private, and I know exactly what I want for myself. I tell my clients, don't worry. These people do this on a regular basis. They know they can assess the capacity. They review the documentation. There's nothing to be afraid of. Even if your child says, I don't want a guardian, it doesn't mean that the mental hygiene attorney will say, this individual doesn't need a guardian. If they can determine that this individual is just saying it because, well, it's just what they're going to say, that's okay. They recognize these things, these characteristics, okay? After the interview takes place, you've gotten your fingerprint, you've served everyone, right, with the citation, you have a hearing day, you appear at court, or whatever the requirement is for appearance. Some appearances will be taking place virtually nowadays versus going to the court. Again, it all differs from court to court. Your hearing will take place. You'll want to check with the clerk at the court because sometimes the letters of guardianship and the order will be issued right then and there. Sometimes some judges will hear all of their matters, and within a few weeks or month, they'll submit an order with the letters of guardianship. It varies. I know that in Westchester County, the judge has a hearing room with every proposed petitioner in the room, hears everything, and within a few weeks, we receive the order and the letters of guardianship. New York County, the judge has a very private interview with the petitioners, and the attorney asks a few questions of both parties, and after you walk out of her chambers, her clerk will prepare the letters of guardianship and the order, and you'll leave the court with those documents in hand. So again, it varies. Sometimes it just depends, but it's something to keep in mind. And these letters, you can always request for more letters than one. We would suggest that you do so because you want to keep these and even give them to, the successor guardians, and or if there's two guardians, both guardians can have copies of these letters of guardianship. And we want to keep them in a safe place, potentially a fireproof safe, or carry them on your person. The original, or the extras you want to keep away, but keep one on your person in case it ever comes to be. I would also recommend that you share that with your child's physicians or medical professionals, because that's one of the biggest issues, right? When the individual turns 18, the doctors are required under HIPAA to not disclose anything to even the parents. A lot of doctors, even at a younger age, don't disclose medical information to parents of their patients. So you want them to know that you have the authority to get this information. If you have guardianship over the property of that individual, you want to take a copy to the bank with you, right? If you're seeking to open a guardianship account or an Eval account, for example, you want that copy to prove that you're a guardian of that individual. The purpose of guardianships is to continue making decisions for that individual, to apply for government benefits if necessary, right after the age of 18. Something that parents sometimes think is that, well, now I'm the guardian, I can avoid or prohibit my son or my daughter from procreating or getting married. That's not the case. Guardianship is a plenary guardianship. 17A guardianships are plenary, but they do not remove the individual's constitutional rights. So you cannot force sterilization. You cannot prohibit them from getting married. If they want to go out and vote, they're allowed to go and vote. So keep these things in mind when you're considering guardianships And also keep in mind that there are alternatives, right? There's advanced directives, there's supported decision making. Any questions? If you have any questions, you can type them in the chat. And Amanda Ford will also include the link to the courts so you can access documentation if you want to. In case you don't get that link, it is newyorkcourts.gov/courts/NYC/surrogates. She's also included our link to our Facebook page where our presentations are recorded and posted. So Janice, you asked, how recent does a psychological eval have to be? The school only tests every 2 to 3 years. Is that too old? So you want something recent. Ideally, the psychologist who evaluates your child or completes, the affirmation will probably conduct, if it's a psychologist outside of the school, will most likely conduct something themselves. I would say you want to check with the court in your area, in your district, because maybe a 2 to 3 year psychological may be a little outdated. Patricia, what is the filing fee for guardianship in the Bronx? I don't have that information off the top of my head, but you can definitely contact the court on that. And Amanda posted the website for the New York courts. Oh, there she posted. Filing fee in the Bronx is $20. Thank you, Amanda. Amanda, and it's $6 for additional certificates. Amanda's my, Amanda and I work together, and she's my paralegal, but Amanda handles a lot of the guardianship matters at our office. Like I said, we're located in Valhalla, but we do guardianships all over New York State. Any other questions? Patricia, Amanda posted the New York courts. There we go. And if you'd like, you can always contact our office. Liliana Keith, Amanda Ford, Deborah Leone, and Lori Cleary are there to assist and conduct intakes if you need to inquire about guardianships or you're seeking guardianships. Don't wait. These are very important. You don't want to miss that gap, right? You want to usually do guardianships or consider them when your child is around the age of 17 years of age, because it can take some time, and you don't want there to be a gap between young adult to adulthood. So you can always contact our office. Our number is 914-984-2740, and Amanda will also post that information. And every Wednesday we are hosting Lunch and Learns. So there's different topics occurring every Wednesday. My colleagues and I will be doing these virtually until we can have in-person meetings. You're very welcome, Janice. So if anyone has any additional questions, please put them in the chat. And just to confirm, does anyone need Spanish translation? ¿Hay alguien que necesita que haga la presentación en español? Por favor, déjeme saber en el chat. Okay. So with that said, I'll stay on till 12:40 in case anybody thinks of any last minute questions. What age is appropriate to apply? You want to apply for guardianship when the individual is about the age of 17, because again, you don't want to, have them, you miss that gap between young adult and adulthood. Well, thank you so much, everyone, for joining and participating today during this Lunch and Learn. I hope that you all learned something. And remember that our recordings are on our Facebook page. And we look forward to seeing you next week. Wishing you all lots of health this week, and have a great rest of the week.